The Museum of Religious Freedom was imagined as an inclusive virtual space for archiving, learning, and critically reflecting on the complex histories and contemporary concerns relating to the freedom of religion or belief in Sri Lanka.
Thematic areas within the museum have been informed by the mapping of 70 events and incidents related to religious freedom and is a place for exploratory learning spanning from the colonial period to the present day.
We invite you to discover the virtual spaces made up of digitized artifacts and architectural elements, archival documents, audio-visual content, community conversations, and expert commentary focused on issues related to the freedom of religion or belief in Sri Lanka. Join us.
Good evening, everyone. My name is Mike, and welcome to the last of a series of webinars organized by Minor Matters on the Museum of Religious Freedom, which is currently under development. The trailer you just saw very briefly introduced you to the museum, which of course has been the basis of all our conversations. In case you're new to Minor Matters is a national campaign to advance the freedom of religion or belief and promote religious harmony in Sri Lanka. We particularly work with youth, but also other stakeholders to increase literacy on and promote social respect for religious freedom in the country. But before we go any further, we want to take a moment to thank you for joining us on a Sunday evening to be a part of this conversation. Our aim, therefore, is to make this as engaging and as meaningful as possible. Let me also at this moment briefly comment perhaps on the Museum of Religious Freedom and what it's all about. I think most of us here, maybe all of us here, would agree that religious freedom has been a contentious topic in Sri Lanka. While the history concerning religious freedom has been fraught with complexity, the present too, as we all know, has had its fair share of challenges. Okay, so the Museum of Religious Freedom has been envisioned and developed as an inclusive space to archive, to learn, and critically reflect on these complex histories and contemporary concerns in relation to religious freedom in Sri Lanka. And space is also digitally immersive, and we have used technology to amplify and to bring to life history in ways that we otherwise couldn't have. And we are glad to say that the museum was a recipient of the Intercultural Innovation Award by the United Nations Alliance of Civilizations and the BMW Group in 2019. In case you're wondering, the museum is under development, but we'll be giving you an opportunity later to visit the space at the end of the webinar and have a sneak peek of sorts. For those who are joining today, let me also very quickly give you an idea of our conversations that have happened over the past couple of weeks. So like I mentioned, this is the fourth of a series of webinars that we've held. And in the first webinar, we spoke about what went into building this museum. So we spoke about the objectives of the museum. We spoke about the research process, the curatorial thinking behind it, and of course, the design and the development. Then in the second webinar, we discussed the relationship between religion and the colonial state. And we discussed the question, how should we confront histories of violence? And then just last week, we explored the question, how should we memorialize violence, which was of course anchored to the civil war and its impact on religious communities in Sri Lanka. So our conversations over the past several weeks have been anchored to our museum, like I mentioned earlier, and it has been anchored to the specific clusters that we've developed in the initial launch of the museum. And in case you miss these conversations, I think we will drop the links now to them and we'll share them with you later on as well. So you could be up to date and join and engage with these conversations that we've had in the past as well. So today we'll be addressing the question, how should we legislate religion, with a specific focus on laws relating to the freedom of religion or belief in Sri Lanka, and particularly how these laws have been used and also not used and sometimes even misused when it comes to matters of religious freedom in the country. And now I have the privilege of introducing you to our moderator and panelists for today. And our moderator is Yamini Ravindran, who is the campaign director for Minor Matters. Yamini is an attorney at law and an ardent advocate for the freedom of religion or belief. And for the past 10 years, she has engaged at the policy level, advocating for greater respect for religious freedom, both locally and internationally, and has strategized key initiatives to build public awareness on the freedom of religion or belief, or FOB, and implemented projects and engaged in strategic litigation to support victims and secure their rights. In 2018, Yamini pioneered the Minor Matters project, which systematically documents FOB violations, trains key stakeholders, and carries out research on key issues and engages in advocacy on pressing concerns in relation to religious freedom. Let me also then very quickly introduce you to our panelists for today. Firstly, we have with us Dr. Gehan Gunatilaka, who is a lawyer specializing in human rights and constitutional law. He is a founding partner of Lex AG, a law firm based in Sri Lanka. He's also a visiting lecturer at the Center for the Study of Human Rights at the University of Colombo, and is due to take up a position as Junior Research Fellow in Religion and Frontier Challenges at Pembroke College at the University of Oxford. Gehan is the author of several publications on religious freedom, including The Chronic and Entrenched Ethno-Religious Violence in Sri Lanka. Next, we have with us Bhavani Fonseca, who is the senior researcher and an attorney at law with the Center for Policy Alternatives. She focuses on research, national and international advocacy, and her work has revolved around assisting victims and affected populations across Sri Lanka, and has engaged in legal and policy reforms and particularly public interest litigation. She's the editor of the book Transitional Justice in Sri Lanka, Moving Beyond Promises. She was also an advisor to the consultation task force appointed by the government of Sri Lanka in 2016, and a member of the drafting committee to formulate the National Human Rights Action Plan for Sri Lanka for the period 2017 to 2021. We also have with us Mr. Amir Faiz, who is a practicing lawyer and is a civil and political activist. He is the chairperson of the Rural Development Foundation that promotes reconciliation amongst Tamils and Muslims in the North and Northwest. He was a founder chair of the Secretariat for Muslims, established during the 2002 peace process. He has also been contributing to the constitutional positioning of the Sri Lanka Muslim Congress since 2001, and was its Director of International Affairs till February 2021. He is also the chairperson of the One Text Initiative, a confidential dialogue process amongst political parties that aims to build consensus on issues. Mr. Faiz has also been publicly articulating reform to the Muslim marriages and divorce law. Then finally, but by no means least, we have with us Shalomi Daniel, who is an attorney at law, practicing in the areas of fundamental rights, administrative, and civil law. She serves as the legal and advocacy coordinator of the Religious Liberty and Social Justice Commission of the National Christian Evangelical Alliance of Sri Lanka. She particularly coordinates litigation relating to religious freedom violations, and is involved in local and international advocacy and research on religious freedom and related human rights issues. So thank you all for joining us today. It's great to have you with us, and I'd like to now hand it over to Yamini. So Yamini, over to you.
Thank you, Mike. So freedom of religion or belief has been a contentious issue in Sri Lanka, both historically and in the present as well. Over the past few weeks, we have been looking at freedom of religion or belief in Sri Lanka from different vantage points. So these included attempts to understand the progression of freedom of religion or belief, which I will hereinafter refer to as FOB, beginning from how the colonial state responded to religion to how the civil war in particular had a bearing on FOB as well. Now, today we are going to explore the area of legislation and religion, or more specifically, how we legislate religion. So as Mike shared earlier, we have been anchoring our conversations to the Museum of Religious Freedom, which is an initiative by Minor Matters. So before I hand it over to our esteemed panelists, I'd like to very briefly comment on the essence of freedom of religion or belief, which I think is an important aspect to consider when discussing how we should legislate religion. Now, there are two aspects to FOB, a forum internum, which is the internal dimension to the right, which concerns the inner realm of thinking and believing of an individual. And then there is forum externum, which is the external dimension or the manifestation of one's religion or belief. Now, forum internum is absolute, and of course, it cannot be restricted for any reason. However, forum externum on the other hand, is subject to limitation. For example, forum internum is enshrined in the Sri Lankan Constitution in Article 10, which states that each person has the right to freedom of thought, conscience, or belief. And this is an absolute right. Now, this also is echoed in Article 18 of the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights. Forum externum is enshrined in Article 14.1e, which provides manifestation rights of foe. This is limited by Article 15.7 and also Article 12, which comprises a non-discrimination clause as well. So now, according to international frameworks, FOB is considered a foundational human right. And as accorded in the Universal Declaration of Human Rights, to the International Covenant on Civil and Political Rights, and also the UN Declaration on the elimination of all forms of intolerance and discrimination based on religion or belief of 1981. Now, moreover, General Comment 22 of the UN Human Rights Committee best defines what FOB really is. It goes on to state that it covers theistic, non-theistic, and atheistic beliefs, as well as the right not to profess any religion or belief, and also how FOB also encompasses the right of freedom of thought on all matters, personal conviction, and the commitment to religion or belief, whether manifested individually or in community with others. And this also includes the right to propagate religion or belief as well. So it is also noteworthy that almost all international covenants and treaties address FOB in their respective agendas concerning different categories of communities and individuals, including women, persons deprived of their liberty, refugees, children, minorities, and migrant workers. Now, law and religion has had its complexities in Sri Lanka as well. And here the problem has lied mainly with the application of the law, with religious minorities facing the brunt of discriminatory practices. Now, legislation on FOB has had various challenges. For instance, the nature of the freedom of religion or belief laws being drafted, for example, limitation clauses, the impact of the law on gender, the law used as a discriminatory tool against minorities in particular, then the non-application of existing laws, and in some instances, biased and arbitrary application of existing laws as well, right? So when we speak about the law, it is impossible not to address challenges stemming from the judiciary as well. As Roger Fink states, when religious freedoms are supported by an independent judiciary, restrictions on religion are reduced. So therefore, judicial sentiment and interpretation is particularly important when it comes to defining the essence, scope, and limits of FOB as well. So ideally, the role of the court is to be divided, to be standing between a constitutional divide, and roots itself, ideally it should roots itself on the side of the individual, whereas the executive or the legislature would stand on the side of the collective interest. Now, according to Diana Shah, the Sri Lankan judiciary has adopted a textualist approach when it comes to limitation clauses, particularly in the incorporation cases. Also, according to the judicial responses to religious freedom, a report published by the NCEASL and Verite Research talks about how the judiciary has showcased a tendency to use a procedural approach when determining outcomes that protect the essence of FOB. This approach has failed to contribute to the substantial expansion of FOB in the country. So with the misapplication of laws to restrict FOB and the threat of further discriminatory laws looming, including laws on hate speech and anti-conversion, it is only timely that we discuss how we should legislate religion. And on that note, without taking much more time, I will hand it over to our panelists. And first, I'll just call upon Gehan to maybe pose the first question to him. Now, Gehan, how have limitation clauses in particular been used in Sri Lanka concerning freedom of religion or belief and rights of communities? And how does this measure against international standards? If you could, for your opening comments, comment on that. Over to you, Gehan.
Thanks, Yamini, and thanks very much for this very kind invitation to speak on what I consider to be a very important topic. So I'm going to talk a little bit about the legal doctrine pertaining to limitations, and then make a few comments on the politics of limitations. Now, Yamini has already explained the two aspects of FOB, and how limitations can only be imposed on the forum internum. That's the internal domain of the person's convictions and beliefs, right? But when it comes to limitations on the forum externum, right, which is the only forum that you could impose limitations on, there are some criteria that need to be satisfied, right? So I want to quickly go through these criteria and then compare the criteria with the actual application of limitations in the Sri Lankan context. So remember, forum internum is the internal domain that cannot be restricted. Forum externum is the more external manifestation of religion or belief, which can be restricted. So that's an important distinction that Yamini has already spoken about. So what are the criteria? Number one, I think it's very important to understand that when you impose a limitation on freedom of religion or belief, or FOB, it has to be by law. It has to be through an instrument that Parliament has some oversight on. In the Sri Lankan context, that would be an enactment of Parliament. And in certain contexts, emergency regulations, which are also subject to parliamentary oversight. So if there are emergency regulations passed for a limited time period under the Public Security Ordinance, that would also constitute law in terms of the first criteria. The next would be the doctrine of necessity. So the restriction has to be necessary. It has to be the last resort and not the first resort. Number three, it has to be in pursuance of some public interest. And here's where things get a little bit more complicated. So what are these public interests? Things that everyone can generally agree on are important and which have an evidentiary basis. So public order is considered to be a public interest. Public health is considered to be a public interest. And then you have all the different rights that are owed to people under the Constitution. If the limitation is in pursuance of one of those interests, it's recognized as within the domain of a permissible restriction, right? Number four, the measure itself has to be proportionate. So often you impose some kind of penalty for the activity that is being restricted. And if that penalty is disproportionate, it would violate the criteria. So for example, if you impose life imprisonment for holding a religious gathering during a public health emergency, that would be considered a disproportionate penalty. So any restriction on this forum externum, on the manifestation of religion or belief, has to be by law, necessary, in pursuance of a public interest, and number four, proportionate. And it is only those specific restrictions that, doctrinally speaking, would be permissible under international law and under our Sri Lankan constitution. Now, bearing all of that in mind, let me turn to the politics of limitations on FOB in Sri Lanka. And I want to make a couple of points. The first, I think, is a fairly obvious one, but the second is really meant to perhaps provoke some reflection. So I'll start with the obvious. In Sri Lanka, there are many instances where restrictions are imposed on FOB under the guise of public interest, but the real interest underlying the limitation is majoritarian in nature. Now take the restriction on the construction of places of worship or the use of certain premises for religious events. NCSL has done a lot of work on this particular subject, and I invite you to read some of the reports that have come out. Some circular or the other will be produced by the police or a local authority official, and the religious group will be asked to discontinue their activities. And often the justification is that the surrounding community is protesting and there could be a disturbance of the peace. So the concept of public order then is abused and exploited to make this particular case, right? And these matters have gone all the way up to the Supreme Court, where the restriction is upheld virtually on the basis of public order. But if you think about it, in reality, it's not the religious activity that is causing the public disorder. It's the threatened reaction to the activity. So a majority community in the area threatens public disorder, and that becomes the basis for restricting the religious activity, which is otherwise completely peaceful, which the minority group is involved in. So then you can see the bad faith application of a limitation in that context. Then, of course, you have the more blatantly bad faith restrictions, such as the ban on burials under the guise of public health, another so-called public interest, right? It turns out that no public health risk is evident in burials, and the restriction was merely a sort of opportunistic restriction against the Muslim community to appease majoritarian and Islamophobic elements within a society. So we need to be extremely skeptical, I think, about the good faith of the state when it imposes restrictions on form, particularly when minorities are involved. So because in practice, the interests that are advanced through these restrictions are just the interests of the majority, which then get passed off as public interest. Now, I want to end by provoking some thought on the scope of form. And this point goes straight to the heart of the current conversation on new laws that set out to regulate religious space in Sri Lanka. So currently, the freedom to propagate one's religion, that is to evangelize and to proselytize, is not considered to be part of the scope of form in Sri Lanka. And this position is very clearly reflected in a recent judgment of the Supreme Court, where it was held that the freedom to propagate one's religion is not really within the scope of form in Sri Lanka. And this was a case that involved the Jehovah's Witnesses community. And in previous bill determination cases, this same position has been articulated by the Supreme Court. Now, doctrinally speaking, that position is not correct because the ability to propagate is very much part of the observance and teaching of some religions. So as long as the freedom to propagate is exercised in a manner that respects other people's rights, and that those rights include the right to hold one's religion or belief without coercion, right? So if by propagation you are coercing someone to change their religion, that would certainly not be within the scope of form. But apart from that, the freedom of propagation has to be part of the scope of form. But there's another point to consider, and I want to leave you with this thought. There's a sort of paradox when it comes to regulating religion, and particularly in the Sri Lankan context. On the one hand, religion is elevated to a special status and is treated as if it is more important than other ideologies and ideas and beliefs in the marketplace, right? That's why we're so sensitive when it comes to criticizing or lampooning religion. But what you begin to realize is that this special status is only afforded to the established religions, to the orthodox religious groups out there. Because on the other hand, religion is given less protection. And this is the paradox. It's given less protection in the marketplace of ideas that, say, political discourse or advertising of goods and services receive. If you're a political party, during an election, particularly the motivations for denying the freedom to propagate, a new religion or a new idea are entirely establishmentarian and serve the interests of already established religious groups. So it is no different to, say, a large group of political parties. So say there are two large political parties denying a smaller, newer political party the freedom to propagate their message, or large monopolies preventing newer manufacturers from advertising. Religion ultimately is just part of the marketplace of ideas, and religions don't deserve a special place, but neither should they be denied the basic freedoms we have come to recognize in other spheres where competing ideas are disseminated. So there is this paradox where on the one hand you give special status, but only to the established religions, but on the other hand, you deny basic freedom of spreading a message to the smaller unorthodox religious groups. So I know my time is coming up, so I'll just sort of wrap up. Because after all established religions were at some point challenges to the status quo. And new religious ideas came forth through a lot of contestation and competition. And we know this as part of our religious history. So the denial of that freedom only serves the political, cultural, and I would say even economic interests of already established religions whose leadership fear the loss of their adherents. So I would say the whole debate on anti-conversion legislation has to be reframed a little. We have to accept that propagation is part of form. And that's not the case in Sri Lanka. And then I think we need to see propagation as part of the natural evolution of a healthy religious sphere. And FOB cannot be just for the established religious groups. In fact, I would argue that it is the smaller, unorthodox religious groups that need FOB the most. I'm going to end there.
Thank you, Gehan. Thank you so much for that. And interesting to listen to the right to propagate and your take on it, and in comparison to how it also stands in the international framework, and also how certain established religions are in fact afforded a particular place, whereas it is, there are the unorthodox religious groups that are not afforded the same equal space as they should be. So on that note, we'll go on to our next panelist, to Faiz Amir. Faiz, your question for you as your opening comments would be to comment on the post-Easter experience and the use of laws to curtail freedom of religion or belief, in particular in the post-Easter experience. Over to you, Faiz. And just before Faiz begins his opening comments, I also want to give a note to the participants. Feel free to type in your questions so that when we go into a time of questions and answers, then we can go into a more meaningful discussion as well. Thank you, Faiz, and over to you.
Thank you, Yamini. Thank you for this invitation, and thanks for Gehan's and also Yamini's opening remarks, which set the tone quite easily, so for us to address straight away to matters that are being contested. Just before going to Yamini's question of post-Easter, may I be permitted to begin that with regard to legislating on religion, if we just go back to our basic law, the supreme law, that is the Constitution, we start on the wrong foot as regards religions are concerned. That is, Article 9 of the Constitution gives Buddhism the foremost place and casts the onus on the state to protect and foster Buddha Sasana. Although Constitution at the same breath guarantees freedom of choice and practice in respect of other religions, there is a distinction that is placed. And this preferential protection that is accorded by itself has led to lesser than equal treatment or protection of other religions or beliefs, or more than an equal treatment to the adherents of Buddhism. Having said that, if I may be briefly to advert to the period leading up to Easter Sunday terrorist bombings, in this context, it will be also pertinent to look at, I mean, in a post-war context, since 2009, as Gehan said, in a political posturing or political background, in pursuit of looking or searching for the other, either by design or default, the Muslims were picked as the other. And then gradually, anti-Muslim activities and hate against Muslims got heightened up since about 2012. The fringe elements or groups from when they come from the Buddhist religious group started enjoying impunity, and then with regard to the curtailment that again Gehan spoke about, being restrictions being placed on places of worship and religious practices, they were looking, the state was looking for means to curtail and restrict minority religions. Then came the horrific incident of the Easter Sunday bombing. And then soon after Easter Sunday bombings, you see, we not only witnessed a flurry of arrests and detention quite arbitrarily using the Prevention of Terrorism Act's provisions as well as ICCPR provisions. We also saw regulations being placed in curtailing willy-nilly against the practices, religious practices or religious and cultural practices, particularly also targeting the women. Now, if you recall, soon after the bombing came the ban on hijab and niqab. Those are the headgears that the Muslim women, some of them or most of them do wear, and also the long dress known as abaya. And then And there was no direct connection or any justification with regard to the terrorist bombing and this dress code. But then they were regulated, regulations were promulgated, and they were banned. And then we also saw a flurry of activities and rhetoric against or propagating reform or banning of madrasas. Then at the time of arrests, we also witnessed any scripture, any literature that had Arabic scripts were being confiscated, because anyone who came in search did not know what it was, what the Arabic scripts meant, but it was all presumed and lumped together as some form of extremist material or material that promote violence. And so much so that the Muslim community even started disposing the holy Qurans that they had in their houses. And with regard to the arrests and detention, using the PTA was used, and ICCPR provisions, which were originally intended as a protection mechanism against the would-be excess of the state, were used by the state to arbitrarily arrest and incarcerate persons belonging to Islamic faith, the Muslims here. From about well over 2,000 that were arrested, and despite various and several representation, currently there are about over 300 persons who have been kept in prolonged detention, and all investigations and inquiries have led to no connection with these 311 people or more, or preponderant majority of them. And what the government did, instead of releasing them, government in March 2021 brought in a regulation in adding to the already draconian provisions of PTA, the regulation titled De-radicalization from holding militant extremist religious ideology. And what the government sought to do was to even bypass the minimum or minimalistic judicial scrutiny that is available under PTA. By this regulation, what the government sought to do was to give some officer in the law enforcement authority to determine that a person is holding extremist religious ideology, and thus label that person so, and then send them to rehabilitation for that person to be de-radicalized, bypassing any judicial scrutiny. And this happens. This was particularly targeted to the currently is being targeted to the 300 odd Muslims who have been kept in prolonged detention over 28-29 months. And this will be, although the Supreme Court, upon being challenged, has put a temporary stop, but the authorities who are holding these persons in detention are pursuing them as well as their families to accept to this, them being sent for de-radicalization, allegedly telling them, if they go to trial or if they go through the judicial processes, their period of incarceration can get prolonged, and so on and so forth. So you see how as Gihan said, existing legislation in their application, how they are being used in different degrees or different variant forms, targeting minority religious persons, and also even the pandemic was also made use to perpetuate or to prolong or to promote this anti-minority religious practitioners. Now, see, at the beginning of the pandemic, the narrative that was let loose was that Muslims as being the spreaders or carriers of virus. And then even the medical fraternity would try to label the densely populated Muslim areas as the places that would generate, or that would be the source of virus spreading. and there was racial profiling that was sought through, and then various attempts were made to kind of sideline that. And then in order to further the same, as Gihan said, the fundamentally protected right of burial was done away with without any reason or rhyme. And when the health ministry's own guidelines permitted conditional burial, when the first Muslim person died on the 30th of March, overnight the regulations were changed, but then in violation of the existing regulation, the cremation was carried out, and then overnight the regulations were altered to ban any form of burial and to compulsorily remit everybody who is thought to have died of or suspected to have died of COVID to be cremated. And then subsequently, by about 11, the health ministry passed a regulation justifying that ad hoc regulation already that was put in practice. So you see the legislations being used or legislative process being abused to target and to vilify or to discriminate practitioners of minority religion. And even today, despite the conditional burial being allowed, even the spirit of it is not being carried out or not being practiced. Now, even today, there is only one designated place as far away in the east in Batticaloa, place known as Otamavadi. One place there where these COVID suspected dead persons are being buried. And there was also a reference made to how the judiciary is behaving. About 11 persons, not only belonging to Muslim faith, but also the Christian and Catholic faith persons petitioned Supreme Court. The Supreme Court heard these applications for 3 days, almost 3 days. And despite one judge dissenting, by majority decision, they just threw away the application, but failing without giving any reason. So, I mean, there is also the perception, the conduct that kind of tells the believers of minority religions in Sri Lanka that, you are not to be treated fairly. Having said that, I think since my time is also coming closer, there is also a kind of a gendered aspect to these religious laws that are being practiced now. For example, within the Muslim community, there has been an agitation for, we have our personal laws, which is known as Menilpa laws, particularly the Muslim Marriage and Divorce Act that governs and regulates the Muslim marriages and divorce and maintenance of children. And that law has been, over a period of time, from the time that it was enacted, it has been found to be discriminating against the Muslim women and girl children. There have been cry and demand for that to be reformed, but then the cry and the demand for reform, although acknowledged by the state, it has been met with very lukewarm attitude. And now, currently, there seems to be some headway that is making, but due to the state's perceived anti-minority stance, the males in the Muslim community and the Orthodox or conservative Muslims who want to perpetuate this discrimination against Muslim women are also trying to take advantage of this anti-Muslim rhetoric as well as the agenda of the regime to say this the reform of the Muslim law is also a part of anti-Muslim agenda, and they are taking cover under it and also arousing the community to say that the reforms are not being demanded by the community, but the government is trying to impose and marginalize or further discriminate the Muslim community, or trying to sort of do away the cultural the heritage or the identity of the Muslim community by reforming the Muslim law. So that, as Gihan said, religions have been enjoying a place that is sometimes not it should have been accorded or deserved, but at the same time it's been used to either marginalize or to discriminate, or also to perpetrate discrimination within a community also. I mean, I'm just confining myself and my remarks to the Muslim community and the laws that are governing the Muslim community. I think as we go along, and my fellow panelists also will address that kind of discriminations and difficulties in other areas as well.
Thank you.
With that, I stop.
Thank you, Faiz. Thank you so much for your, for articulating about the Muslim community and challenges faced by them. And we can talk about that also further in our discussion time. I will also pose my next question to Shalomi Daniel. Shalomi, now Faiz spoke about the Muslim community in particular as well, post-Easter, and challenges faced by the Muslim community. What are the legal restrictions imposed on, on religious minorities which curtail their freedom of religion or belief? And particularly, if you could also comment based on the experiences of the Christian community as well. Over to you, Shalomi.
Thank you, Yamini. So I will deal with specifically two issues. Firstly, with registration of places of worship, and secondly, with how breach of peace provisions are used in an arbitrary and discriminatory manner when it comes to minority religious groups. So firstly, speaking about registration of places of worship, let me speak specifically about a circular that was issued in 2008 by the Ministry of Buddha Sasana and Moral Upliftment, as it was then known. And the circular was addressed to the heads of divisional secretariats as well as certain other local state bodies. And the circular stated that the construction of any new place of worship requires the approval of the Ministry of Buddha Sasana to be channeled via the divisional secretariat. And one of the main points that were to be considered in recommending such approval, and by approval, it was also interpreted as registration, was that the public authority should state whether, in its opinion, allowing the construction of that place of worship would in any way potentially harm religious harmony in that area. Now, this circular, however, has been, the legality of the circular has been questioned and continues to be contested for several reasons. Firstly, because at the time the circular was issued, there was no specific law permitting the relevant ministry to issue such circulars, which will restrict the rights to manifest religion or belief as per Article 14(1)(e) of the Constitution. Secondly, the circular, strictly speaking, does not come within the definition of law under Article 15(7) of the Constitution, and therefore it's questionable as to whether it is a legitimate grounds to restrict Article 14 rights. And finally, despite in 2017, in what is now known as the Panadura Mosque case, though the Supreme Court did refer to the circular and indicate that registration should have been obtained, the Ministry of Buddha Sasana itself and the various departments overseeing Christian and Muslim religious affairs have consistently held that this circular issued in 2008, is applicable only to Buddhist places of worship. So in response to several right to information requests that have been sent by various groups, the ministry continues to date to state that, to hold its position that the circular is only applicable for Buddhist places of worship. Now, the problem and the challenge is that despite the legality of the circular being questioned, despite the ministry itself having at various instances in written form stated that the circular applies only to Buddhist places of worship, at the ground level, the circular continues to be used in a discriminatory fashion against Christian and Muslim places of worship particularly. So the demand is that until and unless such registration is provided, such proof of registration is shown, the places of worship cannot function and the worshippers cannot gather together for worship. Now, since the introduction of the circular in 2008, there have been over 100 reported incidents alone where churches have been forced to shut down, have been forced to stop their worship activities, their gatherings, on the perverted ground of not being able to produce such evidence of registration. The other problem is also that the circular is used for places of worship, not just new places of worship, but places of worship that have existed prior to the circular being issued. And a very good example here would be the Dambulla Mosque, where in 2012, amidst the various allegations and opposition to the mosque, one of the grounds was also that the mosque was not registered with the divisional secretariat. And the mosque has been in existence for several decades prior to the issuance of this circular. So therefore, this causes a challenge and also fear, because it fosters a sense of illegality for something that is constitutionally legitimate. So on one hand, at the ground level, these places of worship are told you cannot function, you cannot continue your worship activities until you register with the ministry and show such proof of registration. And in fact, the demand for this registration is often not just from the divisional secretary or the police, but even from locals, from other religious clergy, who brand these places of worship as unauthorized if they are not able to provide proof of registration on demand. And on the other hand, you have the ministry stating that there is no such process because the circular only applies to Buddhist places of worship. So these minority places of worship are then caught in the middle and have faced several instances where they are forced to shut down. And unfortunately, there have also been certain instances where it has escalated to violence. So that is to do with the issue regarding registration of places of worship. And the second issue that I wanted to specifically talk about was to do with how breach of peace provisions are used in an arbitrary fashion to threaten and control minority places mostly, also coupled with the failure to act or to exercise the law against the perpetrators of violence or threat, as the case may be. So what happens here is sections 81, 98, section 106 of the Criminal Procedure Code are used very often. These provisions are, as you know, to do with breach of peace, to do with public nuisance. And these are used in instances where there is where an individual or congregation is assaulted because of their religious identity, where they are subject to some kind of harassment, maybe because of their religious attire, or where they are subject to threat or intimidation. In all such instances, instead of using maybe provisions such as sections 290 or 291 of the Penal Code, which cover religious offenses, the law enforcement tends to use breach of peace provisions, and that also in an arbitrary fashion to kind of stifle the religious freedoms of the minority religious group. I will conclude with an example, with a very recent example that actually brings together both these issues of registration and also use of the breach of peace provisions. So earlier this year, when lockdown was not in force, when religious gatherings were allowed, subject to certain health guidelines, there was a particular church which had obtained the written approval of the PHI, and in adherence to the health guidelines at that time, gathered together for worship. They were then subject to various threats by a hostile group who demanded that they immediately stop their worship activities and disperse. Interestingly, and maybe unsurprisingly, one of the reasons used was also that they are unauthorized because they couldn't provide any proof of registration. And therefore, when this church then proceeded to lodge a complaint with the police, one of the main actions taken by the law enforcement was to obtain an order under section 106 of the Criminal Procedure Code from the relevant magistrate, which then prevented that particular church from continuing their worship activities for 2 weeks. And the case went on for a few weeks thereafter. And to date, the position of the law enforcement in this case has been one that they cannot allow the church to resume, mainly because they cannot provide any proof of registration. And therefore, they state that if you do not provide proof of registration, that could potentially breach the peace in the area. So I will stop with that example where both these issues were reflected and hand it back to you, Yamini. Thank you.
Thank you, Shalome, for highlighting a very particular challenge faced by Christians in particular as well. The whole registration issues, which has also been an issue for the Muslim community, and the whole challenge of breach of peace cases. On that note, I will pose my next question to Bhavani. Bhavani, what are the challenges faced by minority places of worship? And particularly, if you can comment on the challenges faced by these minority religious communities. And over to you, Bhavani.
Thank you, Yamini, and thank you to the organizers for hosting this event. And having listened to my fellow panelists, I think one of the things I'll try to do is talk about some of the practical issues rather than focus too much on the law. Unfortunately, you have 4 panelists who are all lawyers. But one of the things that I want to speak to also in terms of when we speak about minority religious places of worship is to be very mindful of our political context. And I want to be very clear in terms of what this government has also been, their policies. So one of the documents I think it's worth looking at is the Vistas of Prosperity and Splendor. I keep referring to this because that is the government's policy document. But in that, the president has been very clear in that he said his priority is to protect the Buddhism and the Buddhist heritage. So that is the context that we need to be very mindful when we have these conversations. Now, flowing from that, since November 2019, we've also seen several developments, initiatives by this government that has furthered this policy of prioritizing and protecting Buddhist heritage. One in particular is an institution. So one in particular that I want to really focus on is the Archaeological Task Force for the Eastern Province, which was established in June 2020 by a gazette, and the president has this power to establish task forces, and we've seen quite a bit in the last near 2 years of this government. Now, the Archaeological Task Force is a very interesting creature because it's headed by the Secretary of Defense, composers of Buddhist monks and other officials, includes a media mogul. Interestingly, we haven't seen any minority representation in this task force. And that begs the question as to what is the real purpose of this task force. Now, coupled with the task force are other entities. One is the Buddhist Advisory Council, and I'm raising these things to be very clear in terms of it's not just the laws or the policies, but also the structures that define how things work on the ground. So the Buddhist Advisory Council, just going on media reports, is appointed by the president, composes of Buddhist clergy, meets every month. But again, questions of what really does it do? Now, these institutions apart, there are other line ministries, authorities, departments. We can talk about all of that, but because my time is limited, I just want to be very clear that you have these structures, you have laws, you have regulations. Some of my colleagues spoke to that. But on the ground, what we've seen in the last, at least since 2020, and I spend quite a bit of time in the North and East, so I want to highlight on a few cases, is that there is a trend to protect particular places of religious worship, which is Buddhist places, or the discovery of artifacts that prioritizes the majority religion. And that also marginalizes the minorities. So, for example, in the last few months, the archaeology department, which is an existing institution, predates this government, issued several lists in the North and East. Now, I've seen the list for the Batiklo district, which identifies 600 sites. In Ampara, there is a similar list. In the North, there are similar lists. Now, no one knows how these lists were compiled, what was the rationale for these lists. But on the ground, what seems to have happened, and I've gone to some of these sites, is there is at least information given when questioned, and there's no transparency, there's no proper process, so there's also suspicion as to what happens, is that there seems to be a protection of particular sites, taking over particular sites. So for example, in Trincomalee, it's called the Kuchaveli DS, there are large tracts of land that have been taken over, and there's private land and state land, and I do a lot of work on land issues, so I've looked into these things, but there's also places of religious worship that belongs to the Hindu community and the Muslim community, and they're unable to access these. But in the same time, you have Buddhist clergy that go and take over these sites, and there's no information given. Then you also have the Buddhist department issuing gazettes declaring particular land to Buddhist temples. Now, there is definitely a legal process to follow, but the question with all of these is, are they following to the letter the vistas of prosperity and splendor? And then what happens to minority religions, specifically in the North and East, the Hindus and the Muslims? In the North, for example, I know time is very limited. In Mullaitivu, earlier this year, there was an incident in Kurundumale in Mullaitivu, where there was a trident that was displaced and a Buddhist statue that came about, which created a huge uproar as to why this was done. You had the archaeology department involved, but you also had the military involved. So it's a state policy, it seems, at least from developments on the ground, there seems to be a state policy of prioritizing the majority religion, coupled with militarization, which is creating suspicion, fear, uncertainty among religious minorities in these areas. Finally, I want to also make the point, there's also existing laws that provide for zoning, so creating special areas. Now, Shalomi spoke about the Dambulla Mosque incident in 2012. In that, when you looked at what happened in 2012, where the mosque was attacked, claiming that it was located in a sacred area. Now, as lawyers, we'll start questioning where does this sacred area come about? What's the law? Has it been implemented? And in the Dambulla case, at least, we didn't find any legal basis for the establishment of a sacred area for that particular site. Soon after that incident in 2012, or around that time, the government brought in an amendment to the Town and Country Planning Ordinance, which we actually went to challenge in the Supreme Court, and luckily we were able to stop that bill from passing. But that bill attempted to create sacred areas even on private land. So one needs to understand that there is the politics, the practical issues, but also legislative means and attempts at legislation that could impact places of religious worship in the guise of zoning. So sacred areas, conservation, all sorts of things. And I know my time is up, but just to kind of keep this in mind, that when we talk about legislation, and as lawyers will say laws serve a particular purpose, but what is this purpose that it's trying to serve? Is it also used to target religious minorities? Is it also the lack of information, lack of process, confusion also lead to problems? So in a nutshell, to say there's a plethora of issues, but also ground realities raises this very real danger that the ethno-majoritarian politics is becoming so inherent and divisive that it can lead to other problems. So we have to be very mindful when we talk about laws and implementation in that context. Thank you.
Thank you, Bhavani. We are already running a bit out of, our the time that we were supposed to kind of finish the webinar. However, because we have got quite a number of questions and very interesting questions, I'll just maybe pose a few questions. And if I could kindly ask the panelists to switch on their videos and to also be mindful in terms of responding to the questions and for taking maybe just 2 minutes in responding so that, we can finish in the interest of time. So my first question is over to Gehan. Gehan, there's a question for you. Is there legislation already in force where conversion from one belief system to another is prohibited? Is this legislation according to a recent bill passed in Parliament?
Yeah, in Sri Lanka, there's no such legislation. There have been discussions in the past about such legislation. In fact, a bill was placed on the order paper some years ago, and several petitioners, I believe CPA also was part of the team that challenged that bill back in the early 2000s. And that bill was struck down by the Supreme Court for being inconsistent with certain provisions of the Constitution and didn't get enacted into law. Since then, there's always been the threat of new legislation to restrict, the freedom to propagate one's religion, and it's always been framed as anti-conversion or unethical conversion or forced conversion. So that conversation has taken place, and you would, as expected, see the biggest sponsors or drivers of this discourse being the established religious groups, because they have the most to lose from the idea that others may convince their adherents that there might be another way to look at the spiritual realm, right? So obviously that is where this push is coming from. But of course, in other jurisdictions, like in India, you do have state level legislation that prohibits certain types of conversion activity. It's always framed as forced conversion, but in practice, you would find that even legitimate and perfectly peaceful activities get caught up in these laws.
Thank you, Gehan. And maybe to Bhavani, this question is interesting. There's a question that is coming saying the UK proposes to establish a Truth and Reconciliation Commission to deal with legacies of the Northern Ireland troubles. This will include memorialization initiatives so that the public may understand and learn from the past. So there have been truth commissions also established in other post-conflict countries such as South Africa and Colombia. In order not to repeat past mistakes and protect everyone's right to religious freedom, should Sri Lanka also establish a genuine TRC?
My question is, what is a genuine TRC? Look, that's not a new debate. We've had this since, the previous government promised a TRC. We've had various commissions, including the Lessons Learned and Reconciliation Commission. I'm not opposed to a commission. I want to be very clear, but I think it's also a commission is not going to be solving all the problems. The problems you've heard just today, and I believe even the other events hosted on this issue raises that one institution is not going to solve the problems. You need, and laws alone are not going to solve the problems. So I would say it's a political culture that needs to be addressed. The fact that you need to recognize the pluralism, the tolerance that's needed in a society doesn't come from just a TRC or laws, but it's recognition, it's reckoning. And as a lawyer, I'll say that the addressing the impunity, we have so much past incidents, and the question is how many have even gone to court when there is evidence. So there is a combination, but I think a TRC, it's a conversation to have in terms of what are the modalities, what can be done, but it shouldn't be just a TRC alone. And that's something I think we need to kind of continue a conversation, but not just a TRC. I'm keeping it very brief, Yamini.
Thank you, Bhavani. To Faiz, maybe if I could pose this question in terms of, you spoke particularly in the end of your opening remarks, Faiz, about gender and even how it has an impact on gender as well in terms of religious freedom and personal laws. Would you like to maybe briefly comment on one question is like, what are the implications of it and the consequences faced by it?
Implications of what, Yamini?
Having such restrictive laws concerning gender and religion.
I spoke about the personal laws themselves imposing discrimination within its own community, particularly targeting women and children. So that is not to say that I'm advocating for the complete abolition of personal laws, but personal laws to be reformed. Personal laws have come, say, for example, but if you take MMDA, it was enacted into law in 1951. So that predates our fundamental rights chapters, the concept of equality provisions being brought into the Constitution in 1972 and then slightly expanded in 1978. The idea is that, the personal laws that are personal laws as well as other laws that are discriminatory, although they are being protected by the Constitution as of now, the expectation of the Article 16 protects them being challenged. The idea in constitutional law why a protection of that sort is retained is in order for the particular laws or the community's cultural laws to be reformed, to bring the practices up to speed with the constitutional provisions of equality per se. So if the Article 16 was not retained at that time, there would have been a possibility of certain laws becoming kind of void or being challenged, and there could have been a vacuum. So it was all kept in good spirit, but unfortunately everyone had taken undue advantage of it, and no one, particularly the Muslim community, or even if you take the land reform law, the state has also not proactively persuaded to in terms of its own constitutional expectation, principles of directive policies expectation. They are not brought up to speed in reforming the discriminatory provisions within each laws. So personal laws, therefore, need to be brought up to speed with the constitutional protection that is afforded to each and every citizen, to be, whether within intra-religion or inter-religion, for people to be treated equally.
Okay, thank you, Faiz. Thank you for your take on that. Shalomi, if you could briefly comment on what are some of the legal trends concerning what you have seen concerning religious minorities in particular during the pandemic period.
Yes, thank you, Yamini. I will maybe just also connect it to what I spoke about earlier to do with registration, and mention that during the pandemic and actually even post-Easter, this call for registration took on a slightly different angle as well. So whereas, as I mentioned before, traditionally the divisional secretariat or the police have been the ones mainly demanding proof of registration, following the Easter attacks and even the outbreak of COVID-19, intelligence officials have also been visiting these places of worship and asking to see their registration. And in addition to the usual questions asked, such as how many members and who's the main priest, etc., there have also been questions asked with regards to what is your denomination, what kinds of religious practices and observances do you follow. And what has been worrying is also that the response has been that we are collecting this information because we have been asked to, but these places of worship are not told what is to be done with the information, why is it being collected, who has asked that this information be collected, etc. And therefore, this has naturally also stirred a lot of fear amongst these religious groups. So that has been one issue where this registration has kind of taken on a whole new angle after the pandemic. And secondly, maybe also the fact that even during those periods of time where religious gatherings, etc., were allowed, And despite these places of worship sticking to the the maximum numbers allowed, social distancing, having facilities to wash their hands, etc., they have still been asked to shut down and to stop their activities, stating that they are breaching health guidelines. And if that fails, then they go back to registration. So I think the same issues have continued, just exacerbated due to the pandemic and other events.
Thank you, Shalomi. And I think maybe my last question to all the panelists, and maybe one of you could take that on. And with that, we will end the panel discussion. And that is now, law has also been used as a tool to protect groups, but also law has also been an issue as well, and how it has been used as a discriminatory tool as well. So if one of you can take on this last question of, okay, what can be done to strengthen the legal regime relevant to religious freedom in Sri Lanka, or freedom of religion or belief, and how do we move forward? So over to one of you to respond to that. Gehan, I see your video switched on, so you could.
No, I only
definitely
switched
comment
it
on.
on. I only switched it on just out of politeness, not to not to volunteer. If someone else has a better answer, I mean, I can just say one thing. I think the question is itself a little problematic. I think looking to the law is not a healthy way of seeking answers for religious freedom. The law should really be regulating the exception rather than the norm. I think that's really important to understand about religious freedom. Religious freedom should not be legislated on. So in a way, the question should be how should we not legislate religion rather than how should we legislate religion? As far as the constitution is concerned, I think the fact that the absolute aspects of freedom of religion is protected is fine. I think the general limitation clause is all right. I mean, personally, I would not like to see things like public morals as a basis for restricting anything, because public morals is based on other religious views, right? You don't get morals from elsewhere. So in a way, what happens is one religious morality becomes the basis for restricting religious freedom. So there's a sort of paradox or problem there. But generally, I think the laws are fine. What we should be resisting is more laws, as opposed to trying to ask the question, how can we strengthen the law? But that's just my view. Yeah.
Sorry. Thank you, Gehan. And with that, we will end today's webinar on how to legislate religion. And thank you to all our panelists for coming on board on a Sunday evening and for sharing your experiences from freedom of religion or belief perspective. And without taking more time, I will hand it over to Mike.
Thank you, Yamini. As I mentioned in the beginning, we want to give you a sneak peek to the museum. So I think we have sent the link on the chat box now. So feel free to visit the space, but bear in mind that we are still working on it, and we are working on introducing language functionalities in Sinhala and in Tamil and other optimization. So just bear with us as you navigate the space. But if you have any thoughts, any comments, please write to us. I think our email address will be dropped on the chat box as well. And the link will function till tomorrow, 12 p.m. On that note, thank you very much, everyone. It was great having you all join us. And we look forward to keeping you apprised on the development of the museum as well. From all of us at Minor Matters, good night, everyone. Thank you.
Okay. Bye.
Thank you very much.
Thank you very much. Bye.
The Museum of Religious Freedom was imagined as an inclusive virtual space for archiving, learning, and critically reflecting on the complex histories and contemporary concerns relating to the freedom of religion or belief in Sri Lanka.
Thematic areas within the museum have been informed by the mapping of 70 events and incidents related to religious freedom, and is a place for exploratory learning spanning from the colonial period to the present day.
We invite you to discover the virtual spaces made up of digitized artifacts and architectural elements, archival documents, audio-visual content, community conversations, and expert commentary focused on issues related to the freedom of religion or belief in Sri Lanka. Join us.